Please, Your Lordship, in
Yes.
making a mention in item number 19, that is the hearing list, Your Lordship.
Hearing list. Okay, item 19, yes.
Yes, Your Lordship, this was part heard day before yesterday. We were just to see the statute or the authority on the hot pursuit area. With this, Your Lordship, I have some personal difficulty, if I may take your leave and submit now, Your Lordship. It's just that I want to submit section 48 of CRPC, and there is no violation of.
Sure. Wait for the other mentions, just the other mention part.
Or, Your Lordship, if this matter can be posted on next Monday, then.
Okay, Monday.
Okay.
Take it up on Monday. Just say at the request of the learned PP, let this matter be listed again on Mondays. 17. Yes, 17.
I'm deeply obliged.
May it please your Lordship.
Yes,
Lordship, with regard to item number 2, Lordship,
today's list.
today's list, Lordship. We have filed one affidavit in the IL, Lordship. That is not on record, Lordship. Kindly allow to bring the same on record.
Give that slip, we'll call for
Lordship.
it. Yes.
May it please your Lordship.
Ah,
I beg to mention for listing of an bail matter where the arrest itself is per se illegal, can it be on Monday?
okay.
I'm deeply obliged.
Yes.
Lordship, I am instructed to submit a mentioning memo on behalf of
Yeah.
Mr. Majid.
Ha. We are allowing it on Monday.
I'm greatly obliged.
For motion, item number 1.
May I please, Your Lordship?
Yes.
Lordship, this is an application under section 528 BNS for a criminal complaint case number 23 of 2023, pending before CGM Champai.
For quashing.
On quashing, Lordship.
Okay, then.
Lordship, the TCR may be called for. We have served copy to the opposite parties.
Is anybody appearing for the customs? Yes. You have copies of this?
Yes, Lordship, I have received the copy. And Lordship, this case has been filed before the learned CJM Champai, and this matter is handled by another special PP, Lordship. Then at this stage, I may accept notice on behalf of the respondent number 2. Then I'll obtain the instruction.
We'll issue notice to all of the respondents, and you can have your updated CD and whatever else you need.
Lordship, this respondent number 3 is Commissioner Shillong, Lordship. This I'm appointed only for the Mizoram.
Okay. Okay, heard Mr. So-and-so, learned counsel for the petitioner, also heard Mr. So-and-so, who puts in appearance on behalf of the respondent number 2
Lordship,
on
yes.
advance notice. Full stop. This petition has been filed under section 528 of the BNSS 2023, read with section 438 and 442 of the BNSS, praying for setting aside and quashing of the proceedings of the criminal complaint case number 23 of 2023, pending in the court of the Chief Judicial Magistrate, Champai, Mizoram. Full stop. Issue notice. Returnable 3 weeks. Petitioner to serve, to take steps for service of notice on respondent number 3 by registered post AD. Oh, now it is speed post. Speed post.
Please, sir. The case number is 23 of 23.
Sorry?
23 of 23. Criminal complaint number 23 of 2020.
Of 2000?
23.
23 of 23, I said that. I said 23 of 23, yes. List again after 3 weeks.
For
Which shall
omission,
be
item number 2.
That affidavit has come. I think we'll have to wait for some time. There's an affidavit they have filed.
Rajapa, there's an affidavit.
Huh.
Yeah, the Supreme Court has stayed the judgment of the
That's only
division
real.
bench.
Okay.
So this matter can be kept pending till the outcome of the SLP.
Yes, sir.
Yes, madam, by the additional affidavit, only the Supreme Court order.
Do you have a copy?
Yes, yes.
It will take some time to reach the.
The order of the Supreme Court is here.
I'll just have a copy of the additional affidavit.
This may also be kept as a.
Take down, heard Mr. A.R. Malhotra, learned counsel appearing for the petitioner. Also heard Mr. P.J. Saikia, learned senior advocate, assisted by appearing for the respondent number.
I'm for the, we are for the contempt, my lord.
Appearing for the respondents. Okay. An additional affidavit has been filed by the respondents today, bringing on record the order dated 7/11/2025 passed by the Apex Court in SLP diary number 61030 of 2025, whereby the impugned order dated 24/10/2024 has been kept in abeyance, subject to the respondents being permitted to withdraw the sum which has been deposited by the petitioners before the competent authority. Full stop. The learned counsels of the bar are in consensus that this matter may be taken up after disposal of the SLP
Pending before this.
filed before the Apex Court. Full stop. List these matters after 6 weeks.
Rajapa, this IA can be disposed of.
Which is, what is the IA?
IA, they have
Yes.
filed an IA for.
I 194.
IA is for suspending the proceedings of the contempt petition. Keeping in abeyance the proceedings in the contempt petition. So and since so the Honorable
Since it
Supreme
has
Court,
already been stayed, we can, okay.
IA can be disposed of.
List these matters after 6 weeks on a date to be fixed by the registry, by which time the parties shall apprise the court about the status of the SLP. And in the IA you take down, this interlocutory application had been filed praying for, okay. This interlocutory application had been filed praying for keeping the contempt proceedings in abeyance till disposal of the
SLP.
Page 15.
till disposal of the SLP by diary number 61030 of 2025. Full stop. It has the additional affidavit filed in this interlocutory application has brought on record the order dated 7/11/2025, by which the order complained of has been kept in abeyance. Full stop. In view of the above, the contempt proceedings are kept in abeyance as already directed in the orders passed today in the contempt petition. Full stop. List accordingly.
This I can also be disposed of.
We are not disposing it of. We are keeping it in abeyance. We are keeping it listed along with the other one, keeping on record the interim orders granted by the Supreme Court. Yes.
Item number 3.
Lordship,
Yes, sir.
in this, Lordship, the respondents 4, 5 and 6 and the remaining respondents 1, 2, 3, they have been represented by Mr. H. Gupta who appeared on the
May
last
it please
court
the
date on
Lordship.
9/10.
I am appearing on behalf of Mr. H. Gupta, Lordship. For
Mr.
contempt of
Counsel,
Lordship.
Mr. Counsel, when another counsel is making a submission, kindly do not interrupt.
Lordship.
We like to hear one by one. Yes, yes, sir.
Lordship, they are saying that they will have to submit their affidavits. But till date, no affidavit has been filed.
Okay. Yes,
They
what
have
were you
taken-
saying?
Lordship, I am praying some time, Lordship, in this matter to file the affidavit in opposition, Lordship. Also, Lordship, the similar matters are fixed on in the principal seat on 4th of December, Lordship. The date may be fixed after 4th of December,
This
Lordship.
is regarding that,
Direction for payment of interest under section 34 in connection with land acquisition pertaining to the railway line from Bairabi to Saira.
where is the,
It's at page
page 45?
45. The operative portion is at page 46, Your Lordship.
Which are the contempt matters you are saying are listed on 4th? What similar matters?
Similar writ appeal is, Lordship, the same subject matter is there, Lordship. Writ appeal 8 of 2024, Lordship. It is fixed in the principal seat, Lordship, on 4th of December, Lordship.
In this, there is no appeal.
There is no
There is no
appeal.
appeal.
That is what we have noticed.
By an order dated 11/8/2023, the respondents, the authorities of the railway have been directed to make payment.
On 9/10, the order was that they were required to file the affidavit within a
Yes.
period of 2 weeks. Yes. You are Mr.?
Why would we, Lordship?
Okay. Appearing on behalf of Mr. H. Gupta, Learned Counsel, appearing for the respondent number 4, 5 and 6, has submitted that the respondents would pray for a further 2 weeks period to file their affidavit in opposition, full stop. It is noticed that prayers for allowing opportunity to file the response to the contempt petition has been taken on several occasions. Full stop. List these matters again in the second week of December 2025 as a final opportunity to the respondents to file their affidavits. Mr. So-and-so, Learned Senior Counsel, assisted by Mr. So-and-so, has put in appearance for the petitioners. Since the matters are listed before, similar matters, some matters are there saying is listed before the principal bench on 4th. We are keeping this matter on the second week, by which time they'll file their affidavits in the matter, or due course will follow in the month of January. Yes, sir, you take your, you be cautioned. January,
Yes, sir.
yes.
God bless.
Much obliged, Lordship.
Yes.
Item number 4.
Lordship, this is contempt matter. The respondent had submitted that they seek week time for filing their counter, but not yet
Yes,
filed.
madam, you had
Yes,
received
Your
the
Lordship, my
instructions.
sincere apologies. It is I who is at fault. I completely forgot about it. If I may be given just 1 week time, another
Okay.
1 week time,
We'll allow 1 week.
next week.
Yes, heard Ms. So-and-so, Learned Counsel appearing for the petitioners. Also heard Ms. So-and-so, Learned Counsel appearing for all the respondents. Full stop. Ms. So-and-so appearing for the respondents has submitted that the affidavit in opposition is under preparation and could not be filed due to an oversight. Full stop. She accordingly prays for a week's time to file the response to the contempt petition. Prayer is allowed. List this matter in the second week of December on a date to be fixed by the registry along with the affidavit proposed to be filed.
I'm duly obliged.
Item number 5.
My lord,
Yes?
I received instruction in this morning.
Ah,
Then the money has been sanctioned.
if I may, my lord. However, we just received an email copy of that sanction. I know. I cannot say, Papa.
What was the order for? Where is the order of the court?
Payment of rental compensation.
Rental compensation, my lord. Payment for rental compensation is from page number 12.
Okay, now we'll take into account this
My lord.
and we'll list it in the second week of December.
My lord.
Will the payment be done by then
My lord.
or it will take some more time?
My lord, as per that instruction, 3 weeks time may, 3 months time may be given for payment.
After the sanction?
Yes, my lord.
No, 3 months. We'll list it immediately after the vacations.
My lord.
And let us see if the payment comes up. Yes. Mr. and Learned Counsel appearing for the, you are appearing for the respondent number?
For us,
1 and 4.
1 and 4.
1 and 4.
1 and 4 has submitted that she has received instructions that in compliance of the orders of this court, the total amount related to the writ petition, petitions has been sanctioned. To the contempt petition has been sanctioned, and it is likely that the payment would be made within a short time. Full stop. She, however, prays that the matter may be the respondents will be given a further period of 3 months for disbursal of the amount. Full stop. Since the amount has already been sanctioned, this matters again immediately after the, what vacation do you call it?
Winter vacation, ma'am. Winter vacation.
Immediately after the winter vacations, on a date to be fixed by the registry, on which day the learned counsel appearing for the respondent number 1 and 4 shall apprise the court the status of the payment in accordance with the sanction made.
Oblige.
Item number 6.
My lord, similar instruction that I received.
Yes, sanction is there, same order.
My lord.
Same order, item 6. Just check the councils.
Item number 7.
7. Yes.
My lord, I'm for respondent number 1. I'm seeking another 3 weeks time for filing my affidavit.
For the respondent number 1.
Yes, my lord.
Oh, no mediation. What is the matter about?
Well,
Compensation.
Yes, in the year 2020,
So,
the road has been constructed under border area development program,
okay.
and which Nakdora Sora village to Udal Thana and Gulsing Babsora village to Udal Thana. And then without my consent, my land has been destroyed for construction of roads.
We'll need their affidavit. Ms. Swensolon at CGC appearing for the respondent number 1 has prayed for being accommodated for 2 weeks to file the response to the writ petition. Full stop. List this matters again in the second week of December, along with the affidavit proposed to be filed by the respondents. Or you need further time? 2 weeks will do?
Well, 3 weeks may be given.
3 weeks, then it will go after the vacations. 3 weeks, make it 3 weeks. And you say list the matter again after 3 weeks on a date to be fixed by the registry. Don't say second week of December. Okay? On a date to be fixed by the registry.
Oblige.
Mr.
Item number 8.
Appears for the petition. Yes? Number 8.
Okay.
Yes, Your Lordship.
Yes.
I'm representing the respondent number 1 and 2. And I'm seeking another 3 weeks' time, Your Lordship, to file my affidavit.
My Lord, I'm appearing for the respondent number 3 and 4. The same prayer, my Lord.
My Lord, I respectfully object to the prayer made by the Land Council for the respondent.
Yes.
Because
Why?
they have been provided with ample opportunity.
But
for-
it's a matter of regularization.
Yes, my
Unless
lord.
we have the records which you are depending upon, either admitted or denied by them, can we pass orders regularizing your service or denying it? We'll need the response.
Yes.
So we'll give them,
Let be the last chance, my lord.
we'll give them 3 weeks' time, by which time you heard Mr. So-and-so and a counsel appearing for the petitioner, also heard Ms. So-and-so and Mr. So-and-so appearing for the respondents. Full stop. The learned counsel appearing for the respondents have made prayers for accommodation for 3 weeks to enable them to file their response to the writ petition. Full stop. It is noticed that the, don't write it is noticed, you say. Notice in this case was issued on 12th of March 2025. Full stop. The respondents are accordingly allowed 3 weeks' time as a final opportunity to bring on record their stand or their response to the writ petition, failing which the matter may be taken up for consideration on the basis of materials available on record.
Highly obliged, Judge.
Deeply obliged.
Item number 9.
List the matter again after 3 weeks on a date to be fixed by the registry. Yes.
Your Lordship, in this matter, I am yet to receive instructions from the concerned authority. If I may be given some other time, some more time to file affidavit in opposition, Your Lordship.
Again, an acquisition matter.
Yes, Your Lordship. Yes, Your Lordship.
What happens, madam, is when you are you already in possession of the land? Have you taken possession? Or?
Your Lordship, I have not received any instructions
Yes, madam, your
whatsoever.
land has been
Yes,
taken
Your
possession.
Lordship, yes.
No, any possession
You're
without an
claiming a-
acquisition will lead to very high compensation at the end of the day. The sooner the affidavits come up.
Yes.
Ms. So-and-so, Lunar Counsel appearing for the respondent number.
I am appearing for respondent number 1 and 2.
Respondent number 1 and 2. And Ms. So-and-so, Lunar Counsel appearing for the respondent number 3 and 4. 3 and 4?
4.
Only 4? Who's appearing for 3?
My lord, I'm appearing for respondent number 3.
3. And who's appearing for 5 and 6? Yes. And since you're appearing for all these respondents have made a prayer that they may be accommodated for a period of 3 weeks to enable them to file their response. Full stop. It is noticed that the respondents have been seeking time from around June 2025 for filing response to the writ petition. Full stop. List these matters again after 3 weeks on a date to be fixed by the registry, by which time the respondents shall ensure that the response to the affidavit, response to the writ petition is brought on record.
Item number 10.
My Lord, I am for the sole respondent. I may be given 3 weeks' time for filing my affidavit, my Lord.
What is your prayer, sir?
Your Lordship, this is a claim for family pension. This writ petition has been filed in April 2000 this year. So if my learned friend is asking for time, let it be the last chance, my Lord.
Why is it being denied?
My Lord, it's not denied. If your Lordship kindly see Annexure 8.
Annexure 8?
Yes, page 17. The respondent number 5 has admitted that the family pension is payable to the petitioner. Annexure 8, my Lord.
Page 17. Yes.
Here it says that family pension is payable to the present petitioner. So there can be no denial from the respondent, my lord.
Yes, madam, family pension.
Yes, my lord. However, I not yet received any instruction in this regard.
Who is supposed to give the instructions?
The respondent.
Respondent number 4 or 2? Who's supposed to give it? This matter relates to, take down, heard Mr. So-and-so, learned counsel appearing for the petitioner, also heard Ms. So-and-so, learned counsel appearing for all the respondents?
Yes, my lord.
All the respondents, full stop. This matter relates to grant of family pension to the petitioner, full stop. The learned counsel for the petitioner has drawn the attention of the court to the letter dated 26th of November 2018 issued by the
Respondent number 5.
respondent number 5 to the respondent number 4, clarifying that the petitioner is entitled to family pension, full stop. The family pension appears to be payable from 15/3/2017. Full stop. Notices in this case was issued on 28/4/2025. Full stop. However, the respondents are yet to bring on record their affidavit with regard to the contentions raised in the writ petition, full stop, affording a final opportunity to the respondents to bring on record their response, list these matters immediately after the winter vacations on a date to be fixed by the registry along with the affidavit, if any, filed by the respondents.
Obliged, Your Lordship.
Item 11.
Yes.
The regular first appeal is being listed for the first time. We are challenging the judgment in order dated 24/9/25, passed in a money suit, whereby the instant appellant has been directed to pay an amount of rupees 10 lakhs to the respondent plaintiff. Now that, Your Lordship, the main issue out here is that the suit has been decreed in favor of the respondent plaintiff on the basis of a verbal sale deed, and there is no registered instrument. We had come to an agreement, a verbal agreement, that I would purchase 2 properties belonging to the plaintiff respondent. And as agreed, the amount was 24 lakhs. So I initially paid 14 lakhs, and the balance amount was to be paid later on. There's no registered instrument as such. But after some time, I came to find out that the property was in a disputed property. Some other person had claim over the property. So we came to an agreement that the plaintiff respondent would return the amount already paid. And that was our verbal agreement. However, to our utter shock, they filed a money suit against us saying that please pay the remaining 10 lakhs.
Money suit?
Yes. There is no registered instrument. That was the plea taken by us.
It was only on your admission that this was a kind of a deal that the suit proceeded.
But then it was decreed on the basis of the verbal sale deed.
Yes, heard Mr. So-and-so, counsel appearing for the appellants. This appeal is against the order dated 24th of September 2025, passed in money suit number 35 of 2021 by the Court of the Civil Judge, Senior Division 3, Aizawl. Next, issue notice, returnable 4 weeks. Appellant shall take steps on the sole respondent by speed post as well as by usual process. Full stop. list again after 4 weeks on a date to be fixed by the registry along with the service report only.
There's one IA for staying the judgment in order.
We'll have to issue notice. Can we state now?
Not a problem, my lord, because vacations are coming up anyway, so it's all right. Vacations are coming up anyway, so it's all right.
Here also we'll issue notice.
My lord.
In the IA interlocutory application, issue heard Mr. So-and-so, so-and-so. This interlocutory application is praying for staying the operation of the judgment and order dated 24/9/2025 and decree dated 24/9/2025 passed by the Court of the Civil Judge Senior Division 3 in money suit number 35 of 2021. Notices have already been issued in the appeal in the connected RFA, issue notice on this interlocutory application also on the sole respondent. Petitioner to appellate to take steps on the sole respondent by usual process as well as by speed post. Full stop. List along with RFA number 53 of 2025.
I am obliged.
Once we admit the appeal, we can stay the
My lord.
operations.
Item number 12.
My lord, in item number 12, I have to seek another 3 weeks' time, my lord. I have not received instructions yet.
Is who's not giving you the parawise comments? Someone is apprehensive of giving you parawise comments or what? This is for pay revision.
Who's not giving you?
Huh?
Mr. Lordship, pardon?
Who is not giving you the
Instructions.
instructions?
My lord, there are several departments involved, finance and school education. They have to make a consolidated parawise comments. So this take time.
Your prayer is for grant of revision of
The revision of pay 2010 was initially granted to us with effect from 1/1/2006. Subsequently, they cancelled the allotment from 1/1/2006 and they decided to pay us from 1/4/2008.
Okay, where is that letter? I just want to find out who's the authority who can come up with the
It should be the finance department.
huh?
The finance department.
There must be some communication from the finance department.
Yes, my lord.
So where is that? Is it here on record?
Page 55. Page 86.
Page 86. A wrong fixation of pay. Okay.
So early on they were giving us the ROP 2010 from 1/1/2006. But here they have decided that it should be given to us with effect from 1/4/2008, on which date the schools were provincialized, and not 1/1/2006.
Okay. Heard Mr. A.R. Malhotra, Learned Counsel for the petitioners. Also heard Ms. So-and-so who appears for all the respondents.
All the respondents.
For all the respondents. Stop. Yes. The Learned Counsel appearing for the respondents has submitted that the issue involves the fixation of pay of the petitioners under the Mizoram revision of pay rules, and therefore separate affidavits have to be filed on behalf of the respondent number 2 and 3. Full stop. She prays that she may be accommodated for 3 weeks to enable her to file the affidavits. Full stop. accordingly list this matter after 3 weeks on a date to be fixed by the registry along with the affidavit in opposition to be filed by the respondents, if any. Full stop. Yes.
Item number 13.
My Lord, case record has been called for and the same had been received by now.
Eh?
Case record has been called for and the same had been received by now. Yeah. So if it pleases, may the matter be listed for hearing in the next court date.
AD has returned back from the
My Lord, we have received the paper book.
Huh?
We have received the paper
You
book.
have received?
Yes, my Lord.
Paper book is received?
Had been received.
Okay,
My Lord.
so we'll fix it for
Hearing.
hearing.
May it pleases.
Heard Mr. So-and-so learned counsel appearing for the appellant, also heard Mr. So-and-so learned counsel appearing for the sole respondent. Full stop. The paper books have been prepared and are available on record. The counsels have also submitted that they have received the paper books. Full stop. Accordingly, list this matter immediately on the reopening of the winter vacation for hearing. Yes.
Oblige, my Lord.
Item number 14.
Judge, paper book is still awaited.
Huh? Awaited?
Paper book is still awaited.
I have it. I have it.
Okay.
You have not got it? Collect yours.
Judge, we'll clarify your then. Let it come up after 2 weeks. We'll clarify whether we have received the paper book or not.
Okay.
My Lord, we have not received yet.
Okay, heard Mr. A.R. Malhotra, learned counsel appearing for the appellants, also heard Mr. So-and-so learned counsel appearing for the
Respondent number 2, my Lord.
2 and Ms. So-and-so who appears for the respondent number 1. While Ms. So-and-so has submitted that she has received the paper book and the paper book is also available in the records of this court. Mr. Malhotra, counsel appearing for the appellants and the counsel appearing for the respondent number 2 has submitted that they are yet to receive the paper book. Full stop. List these matters again after 2 weeks so that the paper books may be collected by the counsel for the parties.
Item number 15.
My Lord, paper book has arrived, my Lord.
Received?
Yes, yes, my Lord.
Yes. Paper book received?
Yes, received.
So we'll fix it for hearing? Or you want it taken up today?
Can be both, my Lord, definitely.
Huh?
I think it's best that we keep it for hearing, my Lord, fixed for hearing.
Okay. Heard Mr. So-and-so learned counsel appearing for the appellant and also Mr. So-and-so learned counsel appearing for the respondent. Full stop. The paper books have been brought on record and both the counsels have received copies of the same. Full stop. Let this matter be listed immediately on the reopening. Let this matter be listed after 3 weeks on the reopening on a date to be fixed by the registry for hearing.
Oblige.
Oblige, my Lord.
Yes.
Item number 16.
Lordship, I'm there for the private respondents 1 to 4.
Huh. How many respondents are there?
State is 5 to 7, my Lord.
Huh. So all represented.
Yes, ma'am.
None appears for the appellant on call. The respondents are represented by Mr. So-and-so for the respondent number 1
to 4.
1 to 4 and Mr. So-and-so. Respondent number 5 to 7. 5 to 7, full stop. Yes, what is to be done? None appears.
Appellant is absent, sir.
List this matter again after a week to enable the learned counsel for the appellant to put in appearance.
I'll inform him, Your Lordship.
Item 17.
My Lord, in this case, there's a slight delay of 47 days in filing the connected appeal.
Yes. How many days?
47.
47 days, yes.
It's basically due to the fact that, my Lord, the branch office out here in Aizawl, they don't have the authority so on legal matters. So we have to send the documents from here to Silchar, and from Silchar it goes to Guwahati. And Guwahati gives the approval for filing appeal. Then it comes back via Silchar again. So
Did you put in any appearance, did you put in any objection, the petition before the tribunal to contest the matter?
we did contest. We contested the matter.
No,
Your Lordship.
if you want to take, what are the grounds of your appeal?
Basically, it's on the quantum, Your Lordship. Quantum only. Quantum.
Can you?
We are not disputing the policy as such.
No. What I'm saying is, if you want to take up any of the grounds available to the driver or the insured, then you must move an application
Under
before the
149.
tribunal.
Yes, correct.
Was it done?
I believe so, Your Lordship. But in any event, Your Lordship, we are not saying anything against the driver or the owner. We are only on the manner in which the calculation has been made.
What is wrong with that? Computation, yes. What did they find?
Income, Your Lordship, we are on the income. We believe that the income was not sufficiently proved.
Okay, yes. What do you say?
Yes, my lord, in a similar case, this honorable court direct 80% of the awarded amount that I've given a copy to the bench clerk. So, my lord, if the...
Yes. Some copy. Where have you given the copy?
If the delay is to be condoned, my lord, let them at least deposit 50%, my lord. That is humble.
How much are you disputing?
It's fine, Your Lordship.
But then, if you are just disputing the amount, you have to pay up the amount which you are not disputing. You cannot dispute the whole amount.
Understood. Just to place it on record, Your Lordship, although it won't make much of a difference, I would like to place on record that the notice against the owner driver is not yet completed, but they did not contest the case.
He is appearing for the
claimant.
So your grievance is against the claimant. So when he is represented.
Very well, Your Lordship.
You have filed your objection.
Yes, my lord. On 31st 10, 2020.
Take down heard Mr. So-and-so counsel appearing. We are disposing it of them. We'll condone the delay.
Yes.
Subject to their depositing 50% of the awarded amount.
Yes,
fair enough.
With the registry of the court.
And yes.
And then we'll see if we can release the amount to you on the next day. Let it be deposited first. Yes, heard Mr. So-and-so counsel appearing for the applicants. Also heard Mr. So-and-so counsel appearing for the
Respondent 1, 2 and 3.
Respondent number
1, 2 and 3.
1, 2 and 3, who were the original claimants in the before the Motor Accidents Claims Tribunal, full stop. Would it be proper to do it without notice to the driver and the...
As far as they are concerned, Your Lordship, like Your Lordship had pointed out, our grievance is not against the number one. Number two is that they did not contest the case. So, I'll leave it to Your Lordship.
What does the service report say? Acha. Also, Mr. So-and-so appears for the respondent number 1, 2 and 3, full stop. 1, 2 and 3, comma. Who were the claimants before the MACT?
Yes, Aizol, Your Lordship.
Aizol in
MACT 1 of 2021.
MAC case number 1 of 2021.
One.
Full stop. The learned counsel for the applicant has submitted that there is a delay of 47 days in preferring the connected appeal.
My Lord.
And such delay was caused since the applicants did not have an office to deal with legal matters in Aizol, and it was the formalities had to be completed through the office at
The regional office at Guwahati.
through the regional office at
I
Guwahati
apologize.
via
Silchar.
the Silchar divisional office, full stop. He says the delay is minimal and is for reasons beyond the control of the appellants and therefore deserves to be condoned, full stop. The respondent number 1, 2 and 3 have filed their affidavit in opposition
31st 10.
stating that the delay has not been properly calculated. Have you said that? No. Oh, sorry, you cut it out. Saying that there is no proper explanation of the delay and that allowing the appellants to further pursue this appeal after elapse of the statutory time limit, comma, is going to cause inconvenience to the claimants, full stop. I have considered the rival submissions made. Although respondent number 4, 5 and 6 have not appeared and have not appeared, comma, it has been submitted that the respondent number 4 and 5 did not contest the proceedings before the tribunal, and in any case the claim in the appeal is against the benefit allowed to the respondent number 1, 2 and 3. Full stop. Having duly considered the submissions made, comma, I find it a fit case to condone the delay of 49 days in preferring the connected MSc appeal, subject to the deposit of 50% of the awarded amount.
Yes, ma'am.
Within 2 weeks. Full stop.
And my lord, if the claimant may be allowed to withdraw the amount from the
Let them make a deposit first, and then we'll make. Then you file an application.
Okay. Yes,
that you need the money. Then we'll consider. Subject to deposit of 50% of the awarded amount in the registry of this court. First, interlocutory application accordingly disposed of. And in the MSc appeal you write, since the delay has been condoned, since the delay in preferring this MSc appeal has been condoned by the orders passed today in interlocutory application number 109 of 2025, comma, list this MSc appeal for further consideration after 3 weeks, subject to the appellant having deposited the amount directed in the order passed today in IS Civil in number 109 of 2025. Full stop. Yes.
My lord, if a day may be fixed,
Thing is, they will deposit the amount and thereafter the MSc appeal will come up. We have not stayed the proceedings. We have not given a stay of the order.
Okay.
When there is no stay, there is a sword hanging.
Actually, Your Lordship, I was just coming to that. We have submitted another IA for staying the.
I know. But today we have only condoned the delay.
Very well, my lord.
You deposit the 50%. Thereafter we'll stay it.
Very well, Your Lordship.
Now it will be upon you to hurry up the matter for the stay, the deposit and the.
Very well, Your Lordship.
If we consider that today, it will not help you. Since there is no stay, he will press for a stay on the next date. So he will get it listed on the next date.
Very well, Your Lordship.
By that time, you can file your application for withdrawal of the deposited money. Is it
Deeply
not?
obliged.
Obliged, my lord.
Should I be teaching here? No.
My lord?
Should I be teaching all these things here? No. These are calculations you have to make.
Yes.
He's a young member of the bar, Your Lordship. He's a young member of the bar. He's just
Yes.
coming up.
You start early. Where is the harm?
Obliged.
Yes.
Item number 18.
Yes.
Lordship, I'm appearing on behalf of my senior Mr. Villaramera, counsel for respondent 1, 2, and 3.
What happened to the mediation?
My lord, we cannot settle in the mediation.
Not settle in
Yes, my
mediation. Yes, take down. Anybody appearing for the
Yes, my lord.
applicant? Yes, you.
The main counsel is out of station, my lord.
So, my lord,
Yeah.
if you may allow to file a written objection against the IA.
Okay. Mr. So-and-so appears on behalf of, your name?
Samuel Lompuya.
Appears on behalf of,
On behalf of Gaurav.
appears for the applicants.
Yes, my lord.
Mr. So-and-so puts in appearance for the respondent number
1, 2, and 3.
1, 2, and 3. The matter was earlier referred to mediation, and by the communication dated 31st of October 2025, this court has been informed that the mediation did not succeed. Full stop. Therefore, the matter now requires an adjudication on merits. Full stop. Accordingly, list this IA after a week. How much time you want?
2 weeks, my lord, if
After
possible.
2 weeks, allowing the respondents to file their objections to the interlocutory application number so-and-so. Full stop. Yes. 2 weeks to file your objections.
Yes, my lord, I'm obliged.
19 is already done. Anything left?
Supplementary cost list for hearing, item number 20.
Supplementary cost list. Where is it? This is not. 13th. Today is 14th. I don't even have it. Anyway, no problem. Yes.
May please, Your Lordship. My Lord, in this writ petition, we are challenging the illegal and arbitrary termination of our service from different posts under the office of the LADC. And in this writ petition, we are, our prayer is that we be reinstated.
Yes. What happened?
My Lord, initially, the LADC Executive Committee, for the interest of public, created several posts. If I may take you to page number 227.
Yes.
My Lord, before that, I will very briefly state the petitioner number 1 to 6. They are working. They have been working under the sanitation post, and petitioner number 7 to 10. They are under the disaster management and rehabilitation. Okay. So for those posts, the LADC have created several posts, and this is all under the legal sanction of the law. If I may read page number 227. In the interest of public services, the Executive Committee of the Lai Autonomous District Council is pleased to order creation of the following post as number of posts, level of posts in the pay matrix, and head of accounts mentioned against it with immediate effect. Sectional Assistant, Sardar, Data Entry Operator, Group D. Major Head, 34 Sanitation. And on page number 228.
So two sectional assistant, one
Sardar,
data entry operator 1 and group D1.
Group D1.
Okay. Then
page number 228, my lord. This is for disaster management.
Okay.
In the interest of public
posts.
services, the Executive Committee of the LADC is pleased to order creation of the following post as number of posts, level of posts in the pay matrix, and head of accounts mentioned against it with immediate effect. Trainer, data entry operator, field worker. Now these posts have been created. I would like to submit at the outset, my lord, that these posts, they are non-gazetted posts. And nowhere in these provisions of the LADC can it be stated to be gazetted posts. I would like to clarify that at the outset because it will be relevant in my subsequent arguments. And the legality of creation of this post, I have clarified it in my writ petition itself. Earlier, there have been several rounds of litigations before this honorable court regarding similar nature, and the same have been challenged before this honorable court. I have also annexed certain orders of this honorable court. They are in page number 222. I will not go into detail into these aspects, my lord. The crux of the judgment and order in these cases are that according to the 6th schedule of the Constitution of India, the LADC, the Executive Committee, can create these posts. Thereafter, my lord, after the creation of this post,
and what about to make the appointments?
Yes, my lord. After the creation of this post, we were appointed. If I may take you to the appointment orders, they are in page number 239. Your lordship has got it?
Just a minute. We are marking the pages as we go. 239, yes.
This is the petitioner number 1. If I may read, my lord. Subject to approval of the Departmental Promotion Committee and in the interest of public service, the Lai Autonomous District Council is pleased to appoint Gospellal Nunzava, son of so-and-so, as Sardar in level 2 in the pay matrix, plus all other usual allowances as admissible under rules in force with effect from the date he joins duty under the Major Head 34 Sanitation. He will be on probation for a period of 2 years with effect from joining duty. He is posted at LADC Divisional Office, Bungtlang South. He should join duty within 10 days from the date of issue of this order and submit joining report to the undersigned through the head of the department concerned. His pay is fixed at so-and-so and next date of increment will fall on so-and-so.
Yes.
However, my lord, I believe your lordship is also aware of the political situation in LADC. This office order was made on the different government, and after the change of the government there in the LADC, after the change of the administration, immediately we were arbitrarily removed from our post. We were terminated from our post. I will not read all of the other office orders, my lord, because they are more or less the same. The impugned orders, we have annexed it in page number 249. Your lordship has got it? If I may read, my lord. Whereas creation of various posts of clerical and technical staff in the departments of sanitation and disaster management and rehabilitation has been made, vide memo number so-and-so dated Longlai, the 17th September 2020, and number so-and-so dated Longlai, the 17th September 2020, as shown in Annexure A, outside the financial provisions of the annual budget 2020 to 21 and beyond the LADC General Service Rules 2011, which in itself was void ab initio. And whereas the unjustified creation of the said new post of employment being without any financial sanctions will inevitably create shortage of fund and deficit of salary affecting the whole employees of the Lai Autonomous District Council. And whereas the Executive Committee in its meeting held on 13 January 2021 had unavoidably resolved to nullify and revoke the said orders issued via memo number so-and-so, dated Long Lai the 17th September 2020 and memo number so-and-so, dated Long Lai the 17th September 2020, and all the appointments made thereof on the strength of the said orders. Now, therefore, in the interest of the general public and in pursuance of resolution of the Executive Committee meeting dated so-and-so, the competent authority hereby revoked the said orders issued via memo number so-and-so dated Long Lai the 17th September 2020 and memo number so-and-so with immediate effect in consequences whereof the services of the appointees in respect of the above revoked post as shown in annexation number B are hereby terminated with immediate effect. Now, my lord, what we can construe in this termination order, they have terminated us from our service because of mainly two reasons. It's written there in para number 1. One, they are saying our appointment, the creation of this post, they are outside the financial provisions in the annual budget of 2020 to 21. That is one. That is the first reason. And the second reason, they are saying our appointment, they are beyond the LADC General Service Rules 2011, which in itself was void ab initio. These two reasons, because of these two reasons, they are saying they are terminating us from our service. Now, my lord, to answer to determine how and in what manner, or determine whether our appointments were outside the financial provisions in the annual budget, we will have to look into the records of as to how and in what circumstances our posts were created. To answer that question, my lord, if I may take you to the affidavit in opposition of the respondent, my lord. Therein, my lord, they have annexed certain meeting minutes. Now, the reason why, my lord, I am pointing this out is for this honorable court to determine as to how and in what circumstances were the creation of our posts during our time were created. Now, my lord, the annexures, they are handwritten and in Mizo vernacular. The English translation starts from page number 16.
Page number?
The English translation, my lord, starts from page number 19, sorry, my lord. Sorry, page number 20, Annexure 1C.
Okay.
If I may read, my lord, because these things, these meeting minutes, they are very important. Executive meeting minutes extract is copied due to lack of work, personnel, staff. It was directed that the post below be created. A draft addressing the creation of the post was made and is put up for approval and signature. I will not read these two particulars. And it is just below. It is a follow-up of the Executive Committee's minute, and the creation for post to approve and sign is put up for approval and signature. It is a follow-up of the Executive Committee's minutes. What does the finance side have to say about this? This extract, my lord, is important because they are consulting the finance ministry. They are consulting the finance department. And below, please inform the exact condition of our fund. Next page. These are the conditions of our fund during the year 2020 to 21 LADC. Some amount required in a year, salary, so and so they have listed out. And
there will be a shortfall of 400 lakh.
Yes, my lord.
Yes.
As seen in the above, in the note above, even if the amount asked for Mizoram budget salary upon continually receiving as sanctioned will still be 400 lakh short in fund. Not to mention leave, salary, gratuity, commutation will not be possible to give out, and we are still heavily in debt. The situation of our fund is quite dire. So they are actually acknowledging that the situation is dire, that they have been, that there is a shortage of fund. And just below, since the amounts to be used are concerned with post-creation, the Finance and Accounts Department were engaged. The condition of our funds is as can be seen on the pre-page. A lack of funds required during the financial year ending is estimated to be 400 lakhs, approximately, that is being highlighted. From all this, it is therefore being put up for a decision from the authority. On the next page, my lord. If insufficiency of funds is estimated to be about 400 lakhs, maybe post-creation should be cancelled as of now. So they are making deliberations at this stage. And on the next para, the situation of the post-creation and its conduct is as given. The concerned department during the unexpected COVID-19 pandemic. So my lord, our posts were created because of the public interest, because of the COVID-19 pandemic, and also because of insufficiency of staff as well. COVID-19 pandemic, where I believe it should be wherein spread on our land, that is DMNR and Sanitation Department already has a lack of workforce. Due to less staff, it is highly likely that we may be facing a lot of problems in the foreseeable future. So the exact details of the situation on the Finance Department are asked, and upon estimation of monthly salary received, it is safe to say, as of this moment, that there will be no financial problems. Therefore, post-creation will be created as accepted and stated by the Executive Committee. Also, as for the lack of the shorts on funds for salary during the financial year ending March 2021 is expected to be filled up on the revised estimate by the state's governments as usually done previous financial years. The budget of the previous year was passed with fixed insufficient ceiling. So insufficiency in salary will always be present as of this moment. This part is very important, my lord. So as accepted and stated by the Executive Committee, post-creation will go forward as planned. And the next para, post-creation should be created as stated following the CEM above. My lord, what we can deduce from this meeting minute is that, firstly, because of the unfortunate situation of the COVID-19 pandemic, post has to be created, number one. And number two, the department, especially the disaster management and sanitation department, already has a lack of workforce. And during the deliberation of the creation of this post, they are already well aware, the Executive Committee is already well aware of the financial situation. And however, being aware of this decision, they have made a conscious decision, they have made a conscious choice, and they have justified it by saying the financial problems will always be there, and this can be filled up on the revised estimate by the state government. How they have done it in the previous years as well, my lord. And because of these circumstances, my lord, these posts have been created. Now, my lord, because of that reason, it cannot be, we cannot say that these are outside, they cannot now say these are outside the financial provisions of the annual budget, my lord. It holds no water. Now saying in the order that these are outside the financial provisions in the annual budget While they, on the other hand, they are saying this can be managed by a revised estimate, it holds no water. Now the petitioners are suffering because of them. That is the first reason why this has been, why our services have been terminated, my lord. And to answer the second question.
What are you challenging, your termination or the abolishing of the posts? What are you challenging actually?
We are challenging the termination of our services, my lord.
Whatever you are now saying.
Yes, my lord.
Is the termination of your services.
Correct, my lord.
But whatever you are now reading out.
Yes, my lord.
Is the justification for the abolishing of the posts. Whether the post could have been abolished or not.
Because I'm reading those things
you are not
because
finding the connection.
Yes, my lord, but those reasons, because they have stated that in the reasons of our termination of our service, my lord.
If a post is not there, what to do? Where do you serve? Just like creation of a post is in the hands of the
government.
Is not abolishing a post in the hands of the government.
What
you can create, you can destroy.
That is, your lordship is correct in that respect.
One who can appoint can terminate.
But we were terminated arbitrarily, my lord. These justifications, these two justifications, my lord, does not hold water. As I have stated, my lord, earlier, the reason why they are saying outside the financial provisions of the annual budget does not hold water, firstly. And the second reason, they are saying these are beyond the LADC general service rules.
No, sir, what we are asking you is this.
Yes, my lord.
This is a writ court.
Correct.
So what we can decide is the procedure followed in taking a particular decision, number one, whether the due procedure of law was followed.
Correct.
Number two, the reasons, we cannot see the sufficiency of the reasons given. We can see whether reasons are there. And unless those reasons are, I don't like to use the word perverse,
correct,
we cannot interfere because it is an administrative decision to create
correct,
or to abolish a post. Now what you are arguing is for us to decide whether the reasons given were sufficient reasons or not. Can we decide that?
We can, my lord. And my humble submission, my lord, is that according to their submission, according to their the contents of their...
When a post is created...
Yes, correct.
And people are appointed...
Yes, my lord.
There has to be a certain procedure laid down.
Correct.
You go through an advertisement, you go through a selection process, you go through...
Correct.
Now, when a post is abolished, the person serving there have to be terminated. Their services have to end.
Correct.
Now, if there is a certain procedure for appointing persons to a particular post, would the reverse be also applicable when, while terminating services, a certain procedure has to be followed?
Your lordship is correct.
Now we can see whether while terminating you, any process has been followed.
No, my lord. Some of the grounds which I will be raising subsequently is also that principles of natural justice, they have been violated. That is also my ground, my lord. And to answer your lordship's question, whether there is perversity or not in the abolition of the post and in the termination of our service, I think we can deduce that from their affidavit in opposition as well, my lord. My lord, the situation in the autonomous district councils, they are very, very political. I believe your lordship will also be very well aware.
That would be just like saying that decisions here are very, very positive to the petition and decisions there is not very positive. We can't go by that. What are political decisions? What are the mindset of certain, we cannot go by that. Those kind of arguments will not inspire.
My Lord, I think if I read these paragraphs, it will
Which
make things clear.
paragraph?
Affidavit in opposition,
Which part?
page number 7.
Tell us something where we can find out. Yes, this is what we need to decide.
From these papers, my Lord, it is very hard to find out whether there is actual perversity or not. But we can deduce some element of it.
Are you equipped with any law which relates to the abolishing of posts and termination
I
of
will raise
services
it earlier on. I will raise that, my Lord.
You
I
have
will
to
raise
arrange
those
it.
things
Okay.
regarding whether the termination of our service and the abolition of the post are outside, are beyond the LADC general service rules. I will take your lordship to that. But first, if I may read these things, my Lord.
Yes, which part you are reading?
Para number 26 of the affidavit in opposition.
26, yes.
If I may read, my Lord. That the contents of para 25 under reply are stated to be incorrect, it is humbly submitted that it is not mandatory for giving opportunity of hearing during probationary period. Termination can be done without notice if the appointing authority decides so. The reason of termination of their appointment is clearly mentioned in the termination order. They themselves are saying the reason for our termination of the appointment, not only the post for our appointment, is clearly mentioned in the termination order. And your lordship, I believe your lordship is very well aware of the fact that even the Supreme Court on a numerous amount of times have stated that a probationer, like a temporary servant, is also entitled to certain protection, and his services cannot be terminated arbitrarily, nor can those services be terminated in a punitive manner without complying with the principles of natural justice. They themselves have explicitly stated that termination can be done without notice if the appointing authority so decides. That is the perversity, my Lord. And subsequently, in para number 29, I will take your lordship to the law subsequently, my Lord. That the contents, my Lord, your lordship has got it. Para 29, affidavit in opposition, page number 7. That the contents of para 28 under reply is denied. It is further submitted that the action of the respondents in connection with the termination of the service of the petitioners has been done after reviewing the mode of appointment, mode of procedures followed, and that the availability of sanctioned post. It has been proved that the appointment has been done not following the prescribed procedure, and moreover, it has been done in the eve of the general elections to LEDC with a mere intention of gaining votes, so as to enable them retain the power of the executive committee. The allegation is baseless and lacking evidences based on twisting of facts and law, hence not maintainable. Now they are saying our appointments, they were done on the eve of the general elections to LADC because some persons won some votes. That is their allegation, and that is the reason why that shows, my Lord.
You read one sentence before that. The appointment has been done not following prescribed procedure.
Procedure, yes. That part, my Lord,
Now
I will clarify.
26 juxtaposed with 29 is giving a line of thought that the allegation is your appointment is not per procedure.
Yes, my Lord. The reason, my Lord, why they are saying is not as per procedure.
Therefore, it is not on the basis of your satisfactory or unsatisfactory service during the period of probation that that service has been terminated, which can be
Yes.
done without notice, but it is on the basis of finding faults in your process of your appointment.
Correct, my lord.
If that be so, are you entitled to a notice or not?
I will state, my lord. Now they are saying in here, they are
Yes.
saying the prescribed procedure has not been followed. And they are saying the prescribed procedure has not been followed because of only one reason. They are saying our appointment is beyond the LADC General Service Rules. If I may take you to the General Service Rules, my
Yes,
lord. I believe it will not be there in the case record, my lord. So,
what is this?
if I may
big thing that we
furnish
have?
the General Service Rules.
Constitution, conduct of business, etc. Okay, general service rules, you have a separate copy.
I believe, my lord, they themselves will clarify as to how and in what manner we were appointed beyond the LADC General Service Rules. Now, if I may take you to Part 3, Rule 7. Part 3, Rule 7, under the heading Authorized Permanent Strength of the Service. Your Lordship has got it? The authorized, if I may read, my lord.
Yes.
The authorized permanent strength of the service and the number of the posts therein at the commencement of these rules shall be as specified in the Schedule 1 appended to these rules. The authorized, this part, sub-rule 2 is very important. The authorized permanent strength of the service and number of the posts after the commencement of these rules shall be determined by the Executive Committee with prior approval of the Governor from time to time. What we can deduce here, my lord, is that they are stating that our appointments were beyond the LADC rules is because the executive, I believe they will clarify that, but no, what we can deduce here is that our appointments is without the prior approval of the government from time to time. No other reason can be there, which can be stated to be beyond the general rules, my lord. Because no other provisions, the rest of the provisions regarding to probation, confirmation, training, miscellaneous, our humble understanding is that this, what they have stated as to be traveled beyond the rules is the violation of this subsection rule, sub-rule 7, subsection 2. Specifically, the Executive Committee with prior approval of the Governor from time to time. Yes. And, my lord, now if we take into consideration this provision and look into the conduct of business rules. If I may take you to the conduct of business rules, my lord. 2010. We have to read it harmoniously with the 2010 rules, my lord. The same is in, my lord.
Page number?
Rule 27 is in page number 49. This is the LADC Constitution Conduct of Business Rules 2010. 27, my lord. Power and functions of the Executive Committee. Your Lordship has got it? If I may read, my lord. The Executive Committee shall dispose of all matters falling within its purview except certain matters hereinafter specified, which shall be referred to the District Council and then to the Governor for final approval. The specified matters required to be referred to the District Council as mentioned in Sub-Rule 1 shall be as follows. Cases involving any important change in the administrative system of the autonomous district or any important departure from accepted policy or practices. Propose.
You will only G requires
Yes,
appointment of gazetted officers.
G says appointment of all gazetted officers. Now, if we read this provision harmoniously with the said rule, the rule comes in 2011, this conduct of business rules comes in 2010. It is the legislative, it will not be the legislative intent of the LADC while forming these 2011 rules to be in conflict with the 2010 CCB rules, my lord. So reading this harmoniously together, what we can deduce is that only gazetted officers are required to be approved by the governor.
No, that requires a post approval, approval after the decision is taken.
Correct, my lord.
But the service rule says that it is with prior approval of governor. When you want to create a post,
yes, madam,
then the prior approval of the governor is required.
In gazetted post, my lord.
No. When you create any post, but when you appoint any person to a gazetted post, the difference lies there.
Appointment and creation.
Can we read again? This one.
2011 rules, my lord.
What is this? 2011 rules. Please see. Authorized permanent strength of service
Yes, my lord.
and number of posts after the commencement of these rules shall be determined by the executive committee
My lord.
with prior approval of governor. So the authorized permanent strength
My lord.
and the number of posts will be determined with prior approval of governor. How many number of posts are supposed to be there? What is, how many posts will be there retained or created or whatever done? The number of posts has to be with prior approval of the governor.
My
And
lord.
if we come to 2010, what you are reading at page 49, it says that except certain matters herein under specified, which shall be referred to the district council and then to the governor for final approval. It will be referred to the district council and then to the governor for final approval when the matter relates to appointment in the gazetted post. But when
My
a
lord.
post is created or the number of posts are being altered, then a prior approval is required, is what we understand.
My
If
lord.
our understanding is going against your expectations, then we will definitely give you time to come up with better convincing replies. Don't worry, but, don't take this interaction to be final. This is what just we are saying we are understanding as of now.
Yes, my lord.
So,
I also believe, my lord, if your lordship can also grant me that opportunity.
we'll do that.
Because I believe your lordship is also sitting next week. And, but before that, my lord, I think the judgments which we have annexed have also covered these aspects.
The judgment which I had seen at around page 227 or 228, I forget, 226.
My
Let
lord.
us see if we remember correctly. 225, page 225.
Page 225. This judgment relies on the earlier WPC. So if I may take you to the earlier.
Para 7.
Yes, my lord.
Learned counsel for the petitioner submits the petitioners were appointed by the respondent authorities concerned. He submits that the rules of 2010 was framed in exercise of power conferred under so-and-so. He submits rules 27. Provides that the approval of the governor is required to be obtained for making appointment to the gazetted post. But there is no mandate in respect of non-gazetted post. So to make an appointment to a post, Executive Council is very, very competent to do it in the manner it thinks fit, provided it suffices service law mandates.
My lord.
But to create a post is not an issue that we find in these judgments. I had not gone through the file because I was surprised I did not even see the supplementary list. I'm reading it with you.
Yes, my lord.
But here I do not find the issue was one about creation of posts. It was an issue of appointment to a post. So that is where the difference will come in. For appointment, you need to create something. And that is why we had asked in the initial stages that if appointment to a created post requires the state to follow a certain procedure, would termination on abolition of a post also require the state respondents to follow a certain procedure?
My lord.
If that procedure is mandated by law and has not been followed, the result will be different. It will be just like an illegal appointment being set aside, an illegal termination can be set aside.
My lord.
If it is a situation where the abolition of post will automatically lead to your termination, because there is no post, we cannot keep a person. What does a man do once he joins on a promise that if I serve correctly, I will have the source to feed?
My lord.
There must be something there. Thirdly, if a post is abolished, can you be allowed to argue that no, the abolishment is wrong?
I think so in our case, my lord.
And fourthly, once the respondents take a stand that during the period of probation, your appointment having been found faulty, you can be terminated. Now, they are finding a fault with your appointments. Were you entitled to a notice when a fault is being pointed out in your process of appointment? Because a man has to be given a chance to say whether my appointment is correct or wrong. It can be wrong.
Correct.
Despite all your arguments, all your submissions, your appointment may be wrong, may be faulty, may be wrong, and wrong to the extent that the very appointment has to go. But even then, very required to be given a notice. You may have your own answers, we do not know. You may have the answers you are coming up now with. Those answers could have been placed before the respondents and they would have taken a decision on the matter. Because that is what we are finding going through the documents. Of course, we are not framing any frame of mind without hearing the respondent. But these are questions we will need answers to.
My lord.
These questions will come to you, are coming to you.
My lord.
So we don't think this court has the jurisdiction to say whether a post is required in a particular administrative establishment or not. We are none to say that.
My lord.
We have to see whether the decisions have been properly taken or they have been made on what do you call extraneous considerations, things you are trying to point out now. The settled position in law, affidavit will not explain the order. Is it not Govardhan Das, Bhanji and all that?
Correct.
Now, this order doesn't say it was politically motivated, it was this, it was that, nothing.
Yes, sir.
This order says
Correct.
we did not need the post, there was no financial sanction, posts were not required to be carved out, created, we are withdrawing all those posts.
Correct. My lord, but I think we should also consider the policy decision that has been taken during our appointments as well. If we also have to give primacy to the termination of our service, we have to balance.
You have that CRPF or BSF Act or something? Any of the acts? CRPF, BSF, SSB, any act dealing with a particular service? We have the BSF, good too. The BSF is one of the largest forces employing, we do not know how many lakhs, thousands.
My lord.
Even this act says, If it is here, I'll just read it out to you. Because the chapter you have opened up, it is going to have ramifications. Where is it? There was one. There is a provision where the entire force can be disbanded. It vanishes. There is no force. So even that power is with the executive. It is the executive who would decide whether to retain or not retain a post. All we can see is whether the decision was taken correctly or not. It is not here specifically in the other exit was there. So those things, if you are arguing on the line of whether the post can be abolished or not on the grounds taken,
My Lord.
we'll need very serious arguments on that.
Then perhaps, my Lord, as per your Lordship's suggestion, perhaps if I may be allowed to...
because otherwise, as we see, yes, without notice there is a termination.
If this matter may be part heard and fixed for next week, so that I may get the opportunity
next week we don't need it part heard.
My Lord.
This is the bench which is going to take it up. So next week is not a problem.
So that, my Lord, if I can sufficiently answer your Lordship's question regarding the point of law. Actually, my Lord, this is the first time I have argued a service matter case. So, am I...
That is what the proverb says. There is always a first time. Is it not? There has to be a first time.
My Lord.
Start with it. So, yes.
Yes, Lordship.
We are just taking a preliminary stance. We are not completing the arguments.
Yes, Lordship.
What is your stand in the matter?
Lordship, yes. My learned friend has already submitted most of my preparation actually in my favor. Lordship, just one quick sentence, especially from the Lai Autonomous District Council General Services Rules 2011. My learned friend has read out page number 3, and he says what the executive committee had committed error. The only error committed by the executive committee is not getting the prior approval of the governor. But he fails to read the page number 4. Most of the appointments, most of the petitioners, no, in fact, all of them, they were on probation for a period of 2 years. Lordship, if I may take you to para number 14, it is very clear. Para 14, sub-para 2. May I read out with your permission? Lordship? Persons on probation shall be liable to be discharged from service at any time without assigning any reason thereof during the period of probation. It is very clear, Lordship. And also with regard to the appointment letters, Lordship.
So you mean to say that these rules give the power to the executive to put a man in fear that every morning that I am going to office, I may be asked to go back home without assigning any reasons therefore?
No, Lordship, the reason is there. It is on
the provision of law that you are pointing out to us.
Yes, Lordship.
Can it be stretched to understand that a probationer comes from home in the morning enters the office, given a piece of paper, no reasons, just go home. Can it be so?
The reason is...
Can the state do that?
No, Lordship, I
Whatever
don't
number
think
of
so.
rules you make, whatever number of conditions you put up in an appointment letter, unless you have a reason, can you do something? Reason may be correct, reason may be wrong, but without a reason, you will ask a person to go home.
Yes.
Cannot be. So this support on this, I do not think is going to help you. That part, I do not think is going to help you, that you can send him home without a reason, and therefore you are sending home without a reason. That is not how the world functions. You have to show us something more.
Yes, Lordship. Lordship, if I may take you to the appointment letters of the petitioners, it is on page 239 of the...
You did not
petition.
complete your 2 years. When were
My
you
lord.
appointed?
I was appointed on 17/9/2020, and I was terminated. We were terminated from service.
79, 20 and 20th January 2021. Okay.
28 January.
Around 5-6 months of service.
Correct.
Yes.
Lordship, I would like to take you to page 239. There is the appointment letters of the petitioners.
Yes.
It begins with the phrase, subject to the approval of the Departmental Promotion Committee. Lordship, there is no documents to show that the Departmental Promotion Committee had in fact approved the appointment of the petitioners.
Okay.
Also, Lordship, the LADC is constituted under the 6th schedule, and the LACD has ample power to make rules regarding the administration. And for that, as authorized by the 6th schedule...
Just 1 minute.
Yes, Lordship. Yes, Lordship.
So there was no approval of the Departmental Promotion Committee. Was
No,
it
my
placed
lord.
before the committee?
No, my lord. In fact, the Departmental Promotion Committee was not constituted during that time. And as such, no approval was made.
See, if we understand the district council to be an entity, to be an authority,
yes, Lordship,
devoid of the persons who are being the executive secretary or the member secretary or whoever, we have to understand the council to be one entity.
Yes, Lordship.
It is one juristic person, let us say.
Yes.
Now, if the juristic person, if the entity tells the person being appointed that you should join duty within 10 days, in the same appointment letter,
Yes, Lordship.
and subject to approval you are being appointed, you join your duties. So now, he will go out of his duties only when the Department of Promotion Committee disapproves his appointment. If the stand is that there is no Departmental Promotion Committee convened,
Yes.
then that subject to approval part, he cannot go and ask a Department of Promotion Committee to appoint him or to approve it. It has to be done by your part, by the council. The council says, subject to approval, you now join from 10 days, within 10 days, he joins. The council doesn't put it before the Department of Promotion Committee. What happens? Can he be blamed for it?
Lordship, I'm sorry to say that the Departmental Promotion Committee was not there, but there is nothing in the documents of the departments to show that the departmental promotion committee had approved the...
That is what we are asking you.
Yes.
We cannot take that this body, this number of persons is the council. We have to hold the council to be a separate body. Persons sitting in that chairs may come and go. Is it not?
Yes.
Now, when you say that the departmental promotion committee was not convened, it does not have records of giving any approval, the council, the LADC is itself responsible for convening the DPC, placing the papers, keeping records and everything.
Yes, Lordship.
So today can the the council sit and say, oh, we don't have records? They cannot be blaming themselves. Can that be the position?
Yes,
Can the
Lordship.
High Court tomorrow say that I do not have a copy of this writ petition? No person, whoever sits on this chair, he cannot come and say that High Court does not have a copy. Earlier, this thing was wrong. We cannot say that because this is the High Court. It is
Yes,
not me,
Lordship.
it is not somebody, it is the High Court. Very similarly, it is the council. The council will put it up for approval, maybe approve, maybe not. But if the council does not put it up for approval, can the council say that I don't have records of approval? We are not framing any conclusive decision
Yes, yes.
today. We have got some time today. We are trying to find out as to if we keep it for Tuesday next, subject to both of your convenience.
Yes.
If we keep it for Tuesday next, will we be spending time arguing on things which will not be fruitful, or will we come up with some arguments where we can sit down and decide? He has admitted that, okay, fine, first time service law, so
Yes, it's
some
okay.
guidance is...
It's fine with me, Lordship.
And because this argument we are going to reject. The argument that we do not have a record of the approval. You are the council itself. It was for you to place it before the DPC. It was for you to place it before the convene the DPC. Today, just because other people are manning it, the ground cannot be taken that no, our earlier people did not do it. That cannot be the ground. The ground has to be placed before DPC, not approved. That is a ground we can accept. But if the LADC tries to say that we are who the people are running us, then it cannot be accepted by the court.
Yes, Lordship.
Who sits in the chair, we are least concerned. We are concerned with the post of executive secretary, not the person sitting there. He will enjoy the benefits, no doubt. But the decision cannot be his. The decision has to be the council's decision. And the council's decision is, we will create posts. The council's decision is, we will abolish the posts. In between, people are being appointed. Terminated, no notice. What happens in that situation? Is it an executive action which we are not supposed to touch unless there is perversity, unless there is violation of principles of natural justice? Or is it an action of people who are trying to run the executive, giving their own decisions, replacing each other's decisions? Is it permissible? The moment you go to that angle, things will go in a different way. And what has been stated in that order of termination? That it was a wrong decision. We are reviewing that decision now. It was done, it was not done in a proper manner. We were wrong. We review our orders, don't we?
Yes.
So if it is that position, then the issue is different. But if it is, even we judges are not allowed to differ from a coordinate bench, are we? No, we cannot. Because it is the High Court acquainted with the law. You are supposed to stand up and give me the correct law.
Yes, Lordship.
Yes.
My Lord, just to add a layer to your Lordship is correct regarding the DPC, and just to add a layer to that, in the termination letter, in the termination order, it was not even, only two things were stated. DPC promotion committee approval, those things, they are not there as well. And
Exactly. So, the
And the
grounds
question-
taken in the order to terminate you are
Yes.
that the posts were created without there being any necessity, and the requisite procedures not being followed.
Correct.
Those are the two things.
Correct. Only those two aspects.
So, the moment the argument goes beyond that, Govardhan Das Bhanji will come in, Mohinder Singh Gill will come in. Have you heard of them? Mohinder Singh Gill says, whatever is in the order, that has to be understood. A later affidavit by a later man trying to understand the order and trying to justify it by giving other grounds, that will not be permitted in the court. The court will try to understand the order which is before it. So when the order does not refer to those political motives, the order does not refer to the mode of appointment, can we allow that argument in court? You find it out, you got that, what do you call, SCC online and all that.
Yes, Lord.
Find out Mohinder Singh Gill. The case name is Mohinder Singh Gill. All right. Then you have another judgment, Govardhan Das Bhanji. These say whatever is in the order, that has to be justified. No other grounds can be introduced later on. So what you are arguing now, I am going to reject. What he is arguing, political motive, I am going to reject. It's not there in the order. You don't need to argue that. And that he can never prove on paper. But your affidavit is helping him saying that it's a politically motivated thing. So now the council is trying to come out of the robe of the council and become the persons who are running the show. That cannot be allowed again. Is it not?
Yes, Lord.
So we'll have it on Thursday. Probably you'll have tiring Saturdays and Sundays. Try and come up with arguments where
My Lord.
we can have something.
My Lord.
Service law is a field where it's too vast. A lot of things can be done. Precedents can be understood this way and that way, depending on the factual situations.
My Lord.
Okay. Keep it as heard in part, list on. When do you want it? Tuesday or Thursday? Your convenience, I am here.
Lordship, if Thursday, yes, Thursday will be better for
Yes.
me, Lordship.
My Lord.
Thursday?
My Lord.
Okay. But
I'm deeply
other
obliged.
arguments, either both the sides I have to reject.
My Lord.
And luckily these are not things on the writ petition, therefore I can wait for you to come up with better arguments.
My Lord.
Okay, thank
We
you.
are deeply obliged.
Thank you.